Hello, America. I'm Mark Levin, and this is Life, Liberty, and Levin Sunday. Thank you for being here. Two great guests. Representative Michael Waltz is going to be the National Security Advisor, and Dr. Zuhdi Jasser, former U.S. Navy Lieutenant Commander, founder of American Islamic Forum for Democracy, and co-founder of the Muslim Reform Movement. But before we go to our guests, we have this judge in Manhattan who says, we're going to do sentencing next week of Donald Trump. And I'm very disturbed by the legal analysis by defense counsel, former prosecutors who say, okay, look, this may not be a great thing, but at least it gives Trump the opportunity to appeal. The hell are you talking about? Donald Trump is an innocent man. He didn't commit any misdemeanors. He didn't commit any felonies, not in New York State, not at the federal level, not anywhere. He was subjected to a rump trial, to a Stalinist trial that violated at least 4 of his constitutional rights under the Bill of Rights of the federal Constitution. What are you talking about? We have a judge and a prosecutor who timed this case to try and stop Trump from getting the nomination right before, I think it was Super Tuesday, throughout the primary process. And in the general election, he was forced to go into that courtroom. A gag order for a presidential candidate. And we sit here and say, well, you know, at least now he can appeal. Appeal where? In New York? That's not a risky proposition, is it? The New York Gulag is where you go if you don't want justice and you're Republican or conservative. This was a runaway train. It's still a runaway train. 10 days before an inauguration, this guy Merchan, an acting state judge who has no jurisdictional authority in a phony case of this sort to begin with, decides that we're going to have a sentencing hearing. But he writes this 18-page decision that I read, barely literate, but let me suggest he probably had some help from my kook law professor, but nonetheless, it doesn't matter. He says presidential immunity from criminal process for a sitting president does not extend to a president-elect. Gee willikers. Well, once he rules on sentencing, there's an appeal process. That's part of the criminal process, and Donald Trump will be president. And that appeal process will go on throughout his presidency if he's stuck in New York. He says only the president has the authority of the chief executive. A president-elect does not. A president-elect does not. So what is he trying to do here? Smear Donald Trump all during his presidency. Exactly what the Department of Justice in its 2000 memo said is a huge problem at the federal level. That is, you cannot have a sitting president with this stuff hanging over his head. It undermines his effectiveness. It undermines his representation of the American people with foreign governments. Merchan knows exactly what he's doing. He's responsible for this whole damn thing. President-elect immunity, retroactive immunity, so he concocts these ideas that the president's lawyers are pushing for presidential-elect immunity and retroactive immunity. No, they're not. Essentially, he does not seriously address the Supremacy Clause. Why? Because if he did, he'd be out of business. He had no authority whatsoever to oversee this case. It should have been dismissed immediately. But don't worry, we're told by defense lawyers, we're told by former federal prosecutors, look, unconditional discharge, no incarceration. No incarceration. If this clown excuse for a judge tried to put Donald Trump in prison or an ankle bracelet or anything of that kind, what do you think would happen? The Department of Justice would walk into the front door of the Supreme Court, they'd take up the case immediately, and they'd rule against this guy, and they'd put him down. He's evil. Not completely stupid, but he's evil. That's why he didn't do it. That's why no fines, no penalties. That's why Trump doesn't actually have to show up in person, because he doesn't want the case to go where it ought to go, to the Supreme Court of the United States. This is interfering with a presidential election. It's interfering with the presidency. It's interfering with an inauguration. It's federal in every way. And we're stuck in a New York State court. He says this provides the defendant with finality. He sounds like the legal analysts. So he can appeal. So here's the guy who sets the fire and then says, I'm putting out the fire so you can get on with your life. And then he basically addresses but really ignores most of the most pertinent points of the Department of Justice 2000 and 1973 memos. I want to talk about this. I want to remind you of a few things, as painful as this may be. A complete setup of an innocent man. And we're all supposed to sit here and say, okay, they attack the federal judicial system, they attack the state justice system, they attack our primary electoral system at the federal level, they attack the federal electoral system, and now they're attacking the office of the presidency when Donald Trump is president, but it's okay, it could have been worse. What the hell are these people talking about? Bragg charged President Trump with a low-level misdemeanor for which the statute of limitations had already run, and nobody was ever charged with. In the first place, he accused Trump of falsely reporting non-disclosure agreements they called hush money. It's funny. Every press organization that calls it hush money is entered into non-disclosure agreements. It's a non-disclosure agreement. It's the nature of doing business. That's what it is. Then he added 33 counts by charging every entry in the books as a separate crime. So we have 34 crimes. Since the statute of limitations had run, Bragg then increased the alleged violation from a misdemeanor to a felony. Well, how did he do that? Bragg claimed President Trump's real goal was to commit a different crime, thereby reviving the misdemeanor statute, and then he converts it into a felony by talking about an undermining felonious act, which he really would never describe, but everybody knew it was a federal campaign law. But why wouldn't he say so? Because he has no jurisdiction. And neither does Mershon on a federal campaign law issue. Later, Bragg claimed there were other state crimes, election law crimes, another misdemeanor in which the statute of limitations had run. So there were no laws, there were no former prosecutions, they're way out of their lane with federal law. But don't worry, Trump can now appeal within the gulag that is the state New York judicial system. There's not another case in New York that I've been able to find where a prosecutor has combined crimes like this. But what was being alleged did not violate federal election laws. A former chairman of the Federal Election Commission, Bradley Smith, was going to testify as an expert witness in the trial and said, this doesn't violate federal election law. But Judge Mershon, acting state judge, conflicted Democrat hack, rogue judge Mershon, effectively prevented him from testifying. Even at this point, it wasn't stated by the prosecution that the underlying crime was a federal election-connected crime. Why? Because Bragg had no authority to prosecute a case, the basis of which was a federal campaign law violation. And the judge had no authority to adjudicate such a case. Mershon knew this, but he wanted Trump convicted. So he didn't require Bragg to reveal the underlying offense till actually the very end, when it was too late for the defense to do much about it. Think about all this. The non-disclosure agreements were never campaign contributions under federal law. There was no underlying criminal violation. These misdemeanors could not be resuscitated, let alone turned into felonies, let alone turned into 34 felonies. There was no jurisdiction for the DA, no jurisdiction for the judge to be pursuing the case or holding a trial. Mershon's conduct during the trial was also openly and grotesquely Stalinist. He repeatedly and angrily ruled against legitimate motions by the defense. Against most of their arguments, he ruled against legitimate objections during the trial and often angrily admonished the lawyers in front of the jury to send them another message. He berated key defense witnesses. He cut off testimony. He narrowed and directed the testimony of defense witnesses. Meanwhile, Bragg's witnesses could talk about anything they wanted. Sex, sexual allegations, their views about campaign election laws, being the experts that they weren't experts. They could go on and on pretty much about anything they wanted. That testimony wasn't probative. It was prejudicial. A basis for reversal right there, but it didn't matter. And it stacked up the prejudicial testimony, salacious allegations, and Hope Hicks's testimony. She had worked closely with President Trump, with candidate Trump. She had 4 conversations when Trump was president about the payments, when they were being made and so forth, not because it was criminal or surreptitious, because she had those conversations. Trump was president. Also, we have Madeleine Westerhout, testimony on how the president signed his checks. So we have an immunity decision by the Supreme Court. So rather than hold off the case while the court's ruling on immunity relevant to what's going on in that Manhattan courthouse, Merchan's full speed ahead. He was the first one out of the box, and he wanted to be the first one out to try and cripple Trump, defeat Trump, imprison Trump. An acting state judge. But don't worry, Mark, everything's okay. Now Trump has the ability to appeal to the New York appellate courts. But he rules and he says, even in this 18-page preposterous writing the other day, well, I'm not convinced that that has anything to do with immunity. That was all personal stuff. All personal stuff. The whole case was based around personal nonsense and allegations. The jury instructions was a further abomination. Most appalling, Merchan told the jury, you don't have to agree on what the underlying crime is. You have three choices. Multiple choice. It's a multiple choice test. How do you defend yourself against a multiple choice test about what crimes you're alleged to have committed? And giving the jury in Manhattan, of all places, the ability to pick and choose, Merchan set up Trump in every way he could. Every step of the trial, this was a Potemkin trial. You had a courtroom, you had a judge, you had a jury, you had a prosecutor, you had defense counsel. But so what? That was for looks. What actually took place was a disgusting attack on our justice system at the state and federal level. You could choose whatever crime you think. So we have a violation of the Fifth Amendment, the Sixth Amendment, the Eighth Amendment, the 14th Amendments, violation of Sixth Amendment, violation of due process, the Fifth. Defendant has a right to know precisely what they're being charged with so he can defend himself, so his lawyers can competently represent them. This is basic stuff. This goes back to the Magna Carta. It's 1,000 years old, except in Judge Merchan's courtroom. The Supremacy Clause, which he discusses precious little in his 18-page BS document the other day. Supremacy Clause. There's a lack of jurisdiction for Merchan in a federal case, even though there wasn't a federal case, but that's the hook they hung their hat on. Federal election law. Then they added federal tax law. The hell is a DA in New York and an acting state judge in New York adjudicating, quote unquote, underlying federal crimes? Well, that's why they hid the ball right to the end. That's why they gave the jury a multiple choice question rather than said it's federal law, because they'd be out of business. Merchan blocked key testimony from Bradley Smith, like I mentioned, that no federal election law was violated, no federal election law was even involved, while allowing Michael Cohen, multiple convicted felon, to give all his opinion he wanted on the violations of federal election law, of which he's no expert, by the way. The business entries were not false. They were actually accurate. They weren't made public. The non-disclosure agreements were not unlawful. Federal campaign laws were not violated. In fact, they were not triggered. Indeed, the non-disclosure agreements were entered as business expenses in 2016. The FEC reports weren't even followed to 2017. So how could they affect the 2016 election? They didn't. Relying on the judge with filing after filing, and I say this with the greatest amount of respect, relying on this judge who did this purposely, who created this entire scenario, who abused the rule of law at the federal and state level like we've never seen before, to keep filing motions with him in the hopes that he'll dismiss his own baby, his own Frankenstein, was absurd from day one. He orchestrated this travesty. He's a conflicted judge. To go to him, to get help from him, was never going to happen. This is why I repeatedly stated that the matter should be raised directly with the Supreme Court. Get it the hell out of this chain, or you're going to get stuck, or at least simultaneously. You can deal with that chain of appeals and so forth, but try and get it to the Supreme Court. Get it out of the New York gulag. But if you don't give the Supreme Court an opportunity to take the path, there's no path for them to take. I've mentioned here before Bush versus Gore. The late, great Ted Olson, on behalf of the Bush campaign, filed what he called an emergency appeal. You can call it a kumquat. These are called common law certs. Typically, it's a cert of mandamus or something like that, but the court knows what you're doing. There's no official name for these things because they're not statutory. Call it whatever you want. You get it to the Supreme Court and you give it the opportunity. It takes 4 justices to decide whether they're going to take up the case or not. I mean, hell, I could write this brief. Case after case after case. A violation of federal authority, federal jurisdiction, a violation of the federal Constitution, the violation of the positions of the United States Department of Justice, the attempt to damage, in fact, to cripple an incoming president or a presidential candidate. It's all federal. The violations of the Due Process Clause, Equal Protection Clause, the Fifth Amendment, the Sixth Amendment, the Eighth, the 14th, the violation of the federal Constitution. It's splattered all over the place. This wasn't a local case. This wasn't a state case. These are 2 left-wing thugs, one a prosecutor elected, one a state judge, doing what they do to appeal to the Manhattan population, screwing the country, 49 other states, the electorate, and here we have a landslide victory for President Trump, and he's still involved. But don't worry, he's not going to send him to prison. Try it, pal. Just try it and see what the federal courts do to you. Department of Justice, for half a century, has taken a position that basically what Mershon is doing is never to be done at the federal level. Let me ask you a question. You think the Department of Justice position will be, you can't interfere with the federal executive branch and the presidency unless you're a DA or a state judge. Then you can interfere with it all you want. Really? So a DA and a state judge can destroy the constitutional construct at the federal level? The reason the Department of Justice has never written a memo on this is because nobody's ever contemplated it before. We got 15,000 or so DA's offices around the country. Should we just leave this as it is? Well, at least Trump can appeal within the New York system. But what about the office of the presidency? What about the federal Constitution? What about all these issues that have been breached, that have been violated? Just leave them out there for the next presidential candidate to have to deal with? Yes, right. Now, I hope the New York appeals courts and those judges have some sense. Maybe they will. Does anybody really expect them to come through with a 100% correct decision on Donald Trump? It's not just the state judges in New York, it's federal judges in New York. Look what they're doing to Rudy Giuliani, America's mayor, 9/11. They're destroying him. Look what they did in this libel case with Donald Trump, another federal judge. And now look at this state judge in New York. This is a federal constitutional matter that involves our electoral system, that involves our constitutional system, that involves the federal rule of law. And I'm sorry, I admit I've never been a defense lawyer, I've never been a prosecutor, but I've spent 45 years fighting these guys, litigating against the IRS and the EPA, litigating against every federal department, litigating against radical left-wing groups and so forth and so on. It takes a different kind of mindset to fight these people, not litigation, paint by the numbers. School choice, we won that. Landmark Legal Foundation. Bill Clinton being held in contempt, we filed that complaint in Arkansas years ago. The EPA held in contempt for destroying records, we did that. And I can go on and on and on. You know, sometimes when you're representing somebody or when you're coming in a case, don't be so defensive. Don't worry about a loss. You don't do that in football. You don't do that in any sport. You don't do it in the military. Go on the offensive. The worst thing the Supreme Court could have said is, we're not interested in this case, and you'd be right back where you are. But let me tell you something. If the Supreme Court said it wasn't interested in this case, it would bear the brunt of what it decides in that respect, because this is not going away. This is not going away. The floodgates have been opened. So this isn't a great day for Donald Trump. Donald Trump is an innocent man. And what Mershon is doing here is trying to brand him with convicted felon. for the rest of his presidency.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.